Today we're going to be talking about one of the most controversial areas of the criminal law, something that has been at the heart of controversy for several years now and is likely to continue to be at the heart of controversy: Doli Incapax. It's Latin for incapable of evil, and it's a presumption that children between the ages of 10 and 14 are generally incapable of committing crimes. They don't have the necessary mens rea. Now, when I say incapable, I don't mean physically incapable. There's plenty of evidence to suggest that they are physically capable of it, but that they are not mentally capable, unless the prosecution can prove that the child knew that something was criminally wrong, seriously wrong, not just naughty or cheeky. This is already quite difficult to prove if you're a prosecutor, but it became even more difficult in 2016 when the High Court revealed its decision in RP and the Queen. That case made it clear that it is a very hard presumption to dislodge. Specifically, they said two things that made prosecuting kids in this age gap really tough. First, the prosecution can't just rely on the act itself, no matter how gory, disturbing, or vile. They have to prove with real evidence that this particular child knew what they were doing was seriously wrong. That means their background, schooling, and maturity come into the mix, and sometimes expert evidence. It's not about what most 12-year-olds might know, it's about what this one in particular knew. Now, the second thing is that even if that presumption is rebutted once, that's not enough. It doesn't automatically carry over. Each offence, each count, needs to be proven again. So a child might be found criminally responsible for one charge, but found not guilty of the second. Now, you might think that that's all well and good, but there's more, and here's where people tend to get frustrated. Say our 12-year-old is found capable and guilty of a robbery in January. If they're charged again in March for another robbery, even if it's against the same person, that requirement resets. Now, this is a slight oversimplification, but it's almost as if the January finding never happened. So this moral understanding isn't something that's treated as something that sticks, it's assessed fresh in each new case. Now, unfortunately, this isn't where the perceived issues stop. There's a third issue that's at least obvious to most people, and this is the risk of exploitative criminal recruitment of children. Now, because the law has made it so much more difficult to secure convictions, no matter how strong the objective case with children between the ages of 10 and 14, criminal organisations have taken to recruiting children under 14 for risky jobs. Things like running drugs, stealing cars, home invasions, and acting as lookouts, to name a few. The reality of this is that they do this because they know the odds of conviction are quite low. And it's had the terribly unfortunate consequence of now being the dark side of a rule that was designed to protect children. So yes, Doli Incapax is designed to be a rule which protects children who genuinely don't understand the difference between criminal wrong and just naughty. Unfortunately, it also means that prosecutions have become an ever-increasing uphill battle, and that this rule is now being exploited by people who have cottoned onto it. So much so that the children who are frequently in touch with police are caught with videos on their phone of themselves recording crimes, because remember, they are still children, where they say that they are going out to do Doli. So do you think that Doli Incapax is working too well or just right? I'm James Glisson from Glisson & Associates Lawyers, and if you have more questions about Doli Incapax, Children's Court, or any other criminal questions for that matter, I'd love to explain them. Leave them below.